Hello, this is Alexander Cross, criminal attorney here in the San Francisco Bay Area. Be sure to subscribe to our channel, Law Offices of Cross and Associates, if you'd like to learn more about criminal defense. We received an interesting inquiry here on our YouTube channel, Law Offices of Cross and Associates. This has to do with accused of sexually touching a little girl. Let's see. When I was young, 16 years old, I was unjustly accused of touching a 6-year-old girl. It has already been 15 years, and my niece, who accused me, is now 21 and wants to tell the truth, that it never happened. It was all invented by her mother. Well, the first question I have is, were you just accused? Or did the DA file charges against you? And or were you convicted? Because if you were just accused, but there was never an investigation, the police never got involved, you were never convicted, well, then that's basically it. It's over, you know. I mean, I guess it could be reported to the police, and the victim could say, no, that never happened, that's nonsense. No, my mom's upset because of this reason or that reason, or wants to make it up for this reason, and it's over. Now, assuming you were convicted back when you were 16 years old, well, then we have a different story. You might be looking at a potential appeal here. In order to do an appeal, generally speaking, in order to succeed in doing an appeal, generally speaking, you have to have one of three potential situations. Number one, that the judge gave erroneous instructions to the jury when you were originally convicted. However, in this case, there wouldn't have been a jury because if you went to juvenile court, you would know that convictions are handed down strictly by the judge. It's trial by judge, not trial by jury. So that wouldn't apply here in juvenile court. The other one would be if your attorney at the time either didn't have the experience necessary to handle your type of case, or if he's deemed incompetent. In a situation like that, there could be a basis for doing an appeal. The other basis for an appeal is brand new evidence. Evidence that didn't exist at the time, that now does exist to exonerate you. In this situation, we're going to be focusing on brand new evidence. Obviously, the victim's testimony indicating that this didn't happen, the mother made this up for this reason, etc., etc., etc. That would be something that she would have to go to court. She would have to testify to that regard. Of course, the judge would have to buy the story that was the case. Obviously, if there's any kind of documentation, any recorded conversations with the mother indicating that this was all made up, anything like that, that would be the basis to get this case essentially thrown out by way of an appeal. But that would only apply, like I said before, if you were in fact convicted. And the great thing about this, aside from the fact that your record would be clean, is that you would no longer have to register as a sex offender under Penal Code Section 290. Regardless, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the matter of somebody who is refusing to do his field sobriety tests. See you on our next video.